Secretary.
Thank you very much, Presiding Officer. I too very much welcome the opportunity to participate in today's debate. And I would firstly wish to thank and commend the convener and members of the Citizens Participation and Public Petitions Committee for their consideration of the petition from Ms Nicola Murray. And I too would like to welcome Ms Murray to this Parliament, to her Parliament. It is evident to all that the circumstances outlined by Ms Murray and which have driven today's debate are shattering and deeply heartbreaking, and something which no woman should ever have to endure. The petition reflects the most tragic of circumstances from a relationship that was based on the cruel realities of domestic abuse, something which I am committed to address and to respond to as best I can, an endeavour I know that all parliamentarians share. When I was first asked by the committee to consider the petition, I knew I would have to wrestle with the natural instinct to respond positively to these tragic circumstances with some of the realities of my role and responsibilities as Cabinet Secretary for Justice and Home Affairs. But I do very much come to this debate today in the spirit of cooperation, collaboration and compassion. We all want to focus on doing what is right, what is deliverable and what will make a difference. As we've heard from Mr Carlaw, the petition seeks to create a specific criminal offence which would allow the courts to place longer sentences on those convicted of domestic abuse which causes the loss of an unborn child. As a matter of principle, I can fully understand the reasons for this request, rooted as it is in the belief that the current law cannot adequately punish individuals who cause the loss of an unborn child through their violent actions or coercive control. And I noted on the committee's website that there were a number of written submissions alongside those from the Scottish Government. And there are some challenges that we need to think through, to consider what the consequences of progressing such a proposal might be, to evaluate what other options might already exist that currently seek to deliver the same outcome, but also, of course, to consider what else may be required. It is important, firstly, to consider how the current legislative framework responds to the circumstances outlined in the petition. As we've already heard from Mr Carlaw, the Domestic Abuse Scotland Act 2018 created that specific course of conduct offence for the first time, enabling physical, psychological and controlling behaviour to be prosecuted together. The Act makes it a criminal offence for a person to engage in a course of behaviour which is abusive of their partner or ex-partner. The Act criminalises not only physical abuse, but other forms of psychological abuse and coercive and controlling behaviour that were previously difficult to prosecute. In addition, the Act provides a non-exhaustive definition of what is considered abusive behaviour for the operation of the domestic abuse offence. And the Act therefore recognises the multifaceted nature of domestic abuse. And furthermore, Section 1 of the Act it allows imprisonment for a term of up to 14 years. And while I absolutely acknowledge the significant difference between the maximum penalty under the Act and the penalty received in the respect of the case of the petitioner. And with respect, and I hope members will understand that I have, of course, explained in correspondence to committee that there are, of course, independent functions for Police Scotland and the Crown Office and Procurator Fiscal Service to investigate and prosecute cases under legislation which, of course, is independent to ministers. I will, of course, return to what ministers can do. When considering any reports submitted by the police, prosecutors apply the prosecution test set out in their published prosecution code and exercise professional judgment in deciding on the most appropriate charges based on the facts and circumstances of each case. Where there is evidence that a victim has suffered severe injury, including miscarriage, as a result of the accused actions, this injury would be reflected both within the charge libelled against the accused and the forum selected for the prosecution of that offence. And I am aware that the petitioner and others have called for an amendment to the 2018 Act that reflects the impact of the death of an unborn child because of their concerns that current laws are not fit for purpose. As things stand, in terms of our current legislation, the law can ensure that the death of an unborn child is provided appropriate recognition within the criminal justice system. However, that does not mean there is not further action, either legislatively or non-legislatively, that should be pursued. Presiding Officer, I will come to some of the areas that we need to think and feel our way through, but I'll also come to the legitimate points around the merits of aggravated offences. Presiding Officer, while I cannot comment on specific cases, I do know that Section 1 of the Abusive Behaviour and Sexual Harm Scotland Act 2016 can and has been used in similar circumstances to that of the petitioner, where the offence was aggravated by abuse of a partner or ex-partner, where the commission of any offence amounts to domestic violence. And such examples have included custodial sentences being imposed. So this demonstrates that the law in Scotland can be utilised successfully in such circumstances. That's notwithstanding the merits of further debate around other actions, which I'll touch upon a wee bit later. I do share some of the committee's reflections about the clear and evident difficulties in the desire to create a new offence in this area, not least in terms of how it could be proven. It is likely to prove difficult, both medically and causally, to demonstrate, for example, that psychological abuse led to a woman's miscarriage. Any change to the law in this area would also need to consider the possibility of unintended consequences, something which the committee discussed during its deliberations, including the request to extend the law into other areas. And I suppose to get to one of Mr Green's points, examples could include an unhelpful focus on the behaviour of mothers and other household members that may lead to a miscarriage and stillbirth and prosecution for child destruction. And I noted very carefully the evidence from Dr Marsha Scott when she spoke to the legislative provision that is currently available in England and Wales, but also her concerns that there were women victims who were being prosecuted for child destruction. And I say that only in that we need to give matters careful consideration to reach the aims that we want, but to avoid unintended consequences. Mr Green and others have also mentioned the Scottish Sentencing Council, who have clearly stated the opportunities that the court has, that there's nothing to preclude the loss of an unborn child caused by violent actions or coercive control being libelled as part of an offence. However, I also note the work that the Sentencing Council are progressing to develop a guideline on domestic abuse offences, and I await the conclusion to that work. Further to that work, Presiding Officer, I will ensure that the concerns expressed by the petitioner, that forms part of the discussions of the Scottish Government-led Domestic Abuse Justice Partners Roundtable, and I will endeavour to keep members fully informed. In closing, I would reference the comment from Marsha Scott from Scottish Women's Aid, who said that I think the law has the tools that we need, and I referenced such a tool that has been used in the circumstances described by the petitioner. There are also other actions beyond the law that we need to consider. But I will end my remarks, Presiding Officer, by saying that I will continue to listen and to reflect on the contribution of members this afternoon. I will touch more on the arguments in and around aggravated offences in my closing remarks. And once again, I commend the bravery of the lady who brought this petition to our attention.